Hey there. Today I want to tell you about our hearing challenging the constitutionality of the Trudeau government's use of the Emergencies Act in response to the 2022 Freedom Convoy. Now, I've told you in a previous video that our fight over the government's illegal use of this powerful law is not over, and now I'm happy to tell you that our legal challenge is taking place next week, April 3rd to 5th. I'm going to be flying to Ottawa with our team of lawyers on Sunday night, and I'll be giving you guys live updates every night on April 3rd, 4th, and 5th after court to break down what happened. Make sure you subscribe to the channel so you can get those live notifications. Now, we're going to be making arguments in court about a very narrow and specific question about why the threshold for invoking the Emergencies Act in response to the Freedom Convoy was not met. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in these videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. So remember back to early 2022 in Ottawa, these big rig trucks were protesting COVID restrictions. They were blaring horns, camped out for weeks in the heart of downtown. And the protests against these COVID restrictions were taking place on the steps of these massive, hulking gray bureaucratic government buildings, one of which is actually the federal court at 90 Spark Street, which is going to be the same court that is hearing our legal challenge to the government's response to that mass protest, the challenge to the Trudeau government's use of the Emergencies Act. Now, we at the Canadian Constitution Foundation, along with another national civil liberties organization called the Canadian Civil Liberties Association, we are arguing at court that the high threshold to invoke the Emergencies Act was not met, and that the regulations enacted under it, including the freezing of bank accounts, well, that they were unconstitutional. The Prime Minister's decision to use this extraordinarily powerful law has already been reviewed, as you all know, at the Public Order Emergency Commission, also known as the Rouleau Commission. And while they provided at the Rouleau Commission with their final report some valuable insight into and some unprecedented transparency, right? We saw the Prime Minister and otherwise faceless senior bureaucrats getting cross-examined. You know, the report gave us this insight into policing failures, some insight into the ineptitude of government cooperation and coordination. But the end conclusion was really disappointing. While conceding that another decision maker could reasonably reach a different conclusion, Commissioner Rouleau found that the Trudeau government's decision to invoke the Emergencies Act was justified. Now, I have a whole video breaking down that report, which I will link to in the description below. But the good news is that the hearing taking place at federal court April 3 to 5th is not bound by the Rouleau Commission's conclusion, and it will have the advantage of access to some of the testimony and documentary evidence presented during that inquiry, that radically transparent process that included the cross-examination of the Prime Minister and other senior cabinet ministers. And unlike Commissioner Rouleau, the court in this case will make a formal legal finding on the question of whether using the act was justified. The Rouleau report's conclusion is not binding, it is not precedent, it has no legal weight, so this court actually has the power to make orders and rulings like that. Now, this hearing, the government really doesn't want to take place. It is proceeding in the face of all kinds of hurdles that the Trudeau government has thrown up, including they say that the claim is moot, they have opposed the admission of certain evidence from the commission, and they've used basically every type of delay tactic you can think about. They really do not want this hearing to be taking place, but it is happening next week. We are arguing for a declaration that the government violated the law when the Prime Minister invoked the Emergencies Act. Now, this law, the Emergencies Act, gives tremendous power to cabinet, including the power to make new criminal law by executive order without parliamentary debate or advance notice. And in the decade since it was enacted in 1988, Canada has weathered all kinds of things: terrorist attacks, economic hardship, the pandemic, all without ever resorting to the incredible powers contained in the Emergencies Act. And the Prime Minister's first ever use of this law was not in response to a natural disaster or the outbreak of a war, but to a series of noisy and disruptive, but otherwise largely peaceful protests at the Freedom Convoy. The Trudeau government's use of this law is controversial and, in my opinion, maybe the most severe example of overreach and violations of civil liberties that we saw during those 3 pandemic years. The use of the law constituted an unauthorized use of a powerful law because the legal threshold wasn't met. The Emergencies Act contains a last resort clause. It can only be used when there's a national emergency and when there are no other laws at the federal, provincial, or municipal levels which can address the situation. Parliament can't use the Emergencies Act as a tool of convenience. And we know from the testimony at the Public Order Emergencies Commission that many people in policing were saying that all the legal tools were not exhausted, including RCMP Commissioner Brenda Lucki. The Emergencies Act also has another internal threshold that must be met in order to be invoked. In this case, the Prime Minister had declared a public order emergency, which is defined as an emergency that arises from threats to the security of Canada. And threats to the security of Canada has the meaning assigned to it in Section 2 of the Canadian Security Intelligence Act, also known as the CSIS Act. Now, it's not at all uncommon for legislation to incorporate definitions from other statutes by reference this way. And in this case, we know from reviewing 1987 transcripts of Hansard, of parliamentary debate, that the choice to make reference to the CSIS Act was an intentional one by the law's authors. It was designed as a check and balance on the powerful legislation. We also learned during the course of the public inquiry that CSIS did not believe that there was a threat to the security of Canada. But strangely, the Prime Minister, Attorney General, and Privy Council Office bureaucrats thought that they knew better than actual intelligence officials. And they argued that the threshold under the Emergencies Act is different and broader, even though the text of the law makes it clear that they are identical and that they were intended to be identical for a very good reason. Now, this strange and novel interpretation is now going to be subject to judicial scrutiny at federal court, and I can't wait for a judge to sink his teeth into that. Now, Canada's past, our history with legislation like the War Measures Act, it teaches us that emergency powers should never be used except as a last resort. And indeed, being a power of last resort is actually built into the language and threshold of the Act. So review through the courts is now the last remaining guardrail of accountability. Unfortunately, the hearing is not going to be available to watch online, but I will be there in person. So if you follow me on Twitter at @CVanGuyn, I'm going to be posting about what is happening every day, all day during the hearings. And every night after court wraps up, I'm going to be doing a live broadcast from my hotel explaining what happened that day. Make sure to subscribe to the channel so that you get and ring that notification bell. It's a little bell symbol below, and that way you'll get notified whenever I'm going live. You can also support our case and the fees associated with it by making a tax-deductible charitable donation at the ccf.ca/donate. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.